5 seconds to go. Start. She has also submitted that the plaintiff has never resided with the deceased and he was residing with his wife at his father-in-law's house. Stop. She also submitted that the allegations made by the plaintiff regarding the properties being HUF, is not proper as entire properties were self-acquired properties of the deceased. Stop. She has contended that the trial court has, after considering the entire evidence on record, dismissed the suit of the plaintiff and the judgment and decree of the trial court are tenable in the eyes of law. Stop. She had submitted that the plaintiff challenged the same before the appellate court, wherein the appellate court has allowed the appeal by declaring that the plaintiff has got half share in the properties and he is entitled for partition of the same. Stop. That the appellate court have also ordered to partition by metes and bounds and held that the plaintiff shall recover half share in the suit properties. Stop. According to her submissions, the appellate court has committed serious error of facts and law by setting aside the decree of the trial court. Stop. She has also submitted that the observations made by the appellate court regarding the will are not proper. Stop. She has also submitted that the observation made by the appellate court that the deceased Diwala Ghosha died intestate without making any will is not based on evidence on record. Stop. According to her submissions, there is ample evidence on record to suggest that the deceased Diwala Ghosha has executed will and, therefore, the observation of the appellate court is not legal and valid. Stop. Para. She has also submitted that will has been produced at Exhibit 49 and on the basis of the same, the trial court has held that the properties are self-acquired properties of the deceased. Stop. She has also submitted that the plaintiff has not challenged the will on the ground of illness of the deceased and of unsoundness of the mind of the deceased. Stop. She has also submitted that it was challenged only on the ground that the properties were of HUF and the properties were not self-acquired properties of the deceased. Stop. She has submitted that learned First Appellate Court has committed serious error of facts and law in passing the impugned decree. Stop. She has relied on the decisions in case of Narinder Singh Rao versus AVM Mahinder Singh Rao and others, reported in AIR 2013 SC 1470. Stop. Para. Per contra, Mr. Nagesh Sood, learned advocate as an amicus curiae, has submitted that there are two agricultural properties and the deceased was only Karta of HUF. Stop. He has also submitted that the properties being agricultural lands and deceased being Karta of the HUF, the deceased had no right to bequeath the properties in favor of the defendant. Stop. He has also submitted that the deceased has not executed any will and the will produced in the matter is a fabricated one. Stop. He has also submitted that the properties are of joint family properties and, therefore, the plaintiff has half share in the same. Stop. He has also submitted that the trial court has not framed any issues regarding the validity or execution of the will. Stop. He has submitted that the suit was filed for partition only, which is legal and valid. Stop.